Good evening to our guests and welcome to the 25 Bedford Row webinar, which today is being supported by the Female Fraud Forum. The aim of today's webinar is to provide an update on privilege, and it's great to see so many of you in attendance today, including many new names as well, so a very warm welcome to you all. For those of you who don't know me, my name is Sonal Dashani and I'm a barrister at 25 Bedford Row, and I also run the Education Events Committee on behalf of the Female Fraud Forum. I will be your host this evening. We are especially pleased that you're here today when Zoom fatigue has probably long set in. And in fact, for most of you, I think the end of CPD year has also passed. So we are doubly grateful that you are here today. Before I introduce our excellent panel of speakers, just a couple of housekeeping matters, please. The webinar is being recorded and a copy of it will be available in due course from our website. Questions, we welcome any questions, and of course these may arise during the course of the talks today, but in order to keep on top of these, can I please ask that you put any questions in the chat box as they arise, and we'll do our best to get through as many of these as possible at the Q&A session at the end. Some of our speakers tonight will be referring to materials, excuse me, a non-COVID cough, I can tell you, either in the form of slides or PowerPoint in one case. A link to our website where all of this material will be available will be sent to you after the webinar. This will hopefully save you from having to scribble down names of cases and hopefully allows you to sit back and enjoy the presentation. With that, let me introduce our speakers tonight. Our first speaker is Nick Murphy. Thank you, Nick. Nick is a highly regarded junior member of 25 Bedford Row and practicing in all areas of criminal defence. He is especially adept at dealing with legally and factually difficult cases and in cases involving the analysis of complex documentation. He has particular expertise in allegations of white-collar crime, fraud, corruption and bribery, and has experience in all areas of financial offending, including applications for confiscation, compensation and the disqualification of directors. He is going to give us a brief overview of LPP first, looking at the ENRC judgment and developments this year outlining particular cases in which this authority has been applied or where the case disapplied. Our second speaker is Nicola Howard, Queen's Counsel, a leading silk specialising in commercial and business crime, also at 25 Bedford Row. She has appeared in numerous cases, acting on behalf of company officers, SMEs and high net worth individuals involving allegations of bribery, corruption, fraud and money laundering. She undertakes a complex advisory work, and as an innovative tactician, she provides practical advice when assisting in the early stages of an investigation or surrounding financial crime issues. Additionally, she is a certified fraud examiner and sits as a recorder in the Crown Court. Today, Nikki is going to look at the subject matter of those cases that Nick is going to give you an overview of. She's going to be looking at the subject matter of those cases in more detail. And her focus is going to be on particularly on those cases where people didn't manage to retain privilege and a discussion as to why that was in those cases. Last but certainly not least, I'd like to introduce Matthew Ewens. He's a managing associate in the White Collar Crime and Investigations Group within the Litigation Department of Mishcons. He has extensive experience representing both individuals and corporates in cross-jurisdictional bribery, corruption and complex fraud matters, regularly instructed to advise in all areas of associated litigation, including restraint, civil fraud, confiscation and civil recovery proceedings. He has particular expertise in judicial review and the challenge of search warrants, and has experience of providing early advice to clients in both criminal and civil matters prior to the commencement of litigation and where there are parallel criminal factors to consider. He's currently instructed in a number of SFO investigations, as well as advising corporates regarding approaches by law enforcement in the UK and US for assistance under their respective compulsory powers. He is going to, having had the law and cases examined by Nikki and Nick, Matthew is going to give practical advice on what people need to consider. And in particular, this is in the context of internal investigations and how LPP may apply and trying to protect privileged. With that, if I can hand over to Nick, please, for the first part of this presentation.
Thank you, Sonal. I'm just going to wait for screen sharing to be enabled, just so that I can share a few slides with you. Just bear with me one moment. Right. I hope you can all now see my blue slide, and let's get right to it. What I'm going to do in the next 15 minutes or so really is to try and give a brief overview of as it stands at the moment. There have been a great number of developments over the past year or so, especially since ENRC hit the books back in 2018. Of course, because I've only got 15 minutes, this is going to be taken at rather a gallop rather than a canter or even a slow walk. So do bear with me if you think that I've skimmed over things. Feel free to ask questions at the end and I'll try and help out as best I can. Getting straight to it then, let's have a look at litigation privilege. First of all, just a quick definition: confidential material made for the dominant purpose of civil or criminal litigation, and it needs to relate to litigation which is pending, reasonably contemplated or existing. And we'll talk a little bit more about that in the context of ENRC in a minute. Legal advice privilege. This has been a slightly more hot topic over the past year or so. Again, a communication between a client and their legal advisor for the dominant purpose, it now seems, of enabling the client to obtain or for the advisor to give them legal advice. And that will be, I think, a factor for discussion in a few moments' time. And that's regardless of whether or not litigation was contemplated. That is just a very broad overview of the rough definitions of the two types of legal professional privilege, just to give everyone who perhaps may not be as familiar with the different types an equal footing to the rest of us. Before I dive right into the cases, I just want to mention one little area of law which you might not be familiar with, which is SATCAR. SATCAR sounds uninteresting. That is because really it is uninteresting. What it is an area of law which allows investigations by the accounting regulators to look into statutory accounting procedures of major companies. So if, for example, the Financial Reporting Council wants to look into the actions of one of the large major auditors, it will use the provisions in Schedule 2 of SATCAR to look into those. That's a very dull way of introducing this particular topic. But as you'll see in the most recent cases, particularly A and B, which we'll talk about in quite some detail later on, this has proved to be a particularly important part of law. In particular, and the reason why it's important is because there's a specific statutory exemption carved out for documents which may be legally privileged. As you can see from what I'm showing on my screen right now, a notice given by the Financial Reporting Council doesn't require a person to produce any information or create any documents which they would be entitled to refuse on the basis of legal professional privilege. And that has a couple of important consequences, as we'll see later. And the final thing to mention, just for now, is that a failure to comply with the regulations under SATCAR is a criminal offence. And so, as you can imagine, this has been a hotly contested area of law for corporates who really don't want to get into the arena of criminal litigation. And so we come to SFO versus ENRC from all the way back in 2018, when Corona was merely a refreshing beverage as opposed to a virus that affects our day-to-day lives. Just as a quick refresher, this was a case involving alleged fraudulent and corrupt practices in Kazakhstan and in Africa. There was a tip-off by a whistleblower to the SFO who, as you can imagine, weren't particularly pleased to hear about this particular conduct. This concerned ENRC because they were concerned about some form of either civil or criminal investigation into their activities, and this precipitated quite a large amount of internal investigation and internal record keeping over a number of years. To give you a flavour of the concern that was present at ENRC at this particular time, one member of their staff described it as predicting a shitstorm and predicted a dawn raid before the summer's over. this was the level of concern within a large multinational company. So having been through the courts, having been in front of the High Court at first instance, it arrived up in the High Court, up in the Court of Appeal for discussion. And really the issue in that case was looking at what material generated in the course of that investigation was privileged and what was not. And there were 6 issues in total. 3 of the issues involve legal advice privilege, and we'll come on to those in a moment. And then 3 ostensibly dealt with litigation privilege. So the first issue for the judge in that case, for the court rather, was the judge at first instance right to determine that at no stage before the documents have been created that criminal legal proceedings against ENRC or its subsidiaries or their employees were reasonably in contemplation. And really, this is one of the key points to emerge from litigation in recent years. When is criminal litigation reasonably in contemplation? The judge at first instance had really dismissed this as an issue, but in their judgment, the Court of Appeal disagreed with the judge at first instance and said, well, actually, if you look at all the circumstances, and if you look at the correspondence between ENRC and the SFO, if you take everything as a whole, well, actually, it really was the case that criminal proceedings were reasonably in contemplation. And there's a slight tension in that particular decision between this and another case, which we will look at just very briefly in a moment. The second issue, as you can see on the screen, was the judge right to determine that none of the documents were brought, I suppose you should say, into existence for the dominant purpose of resisting contemplated proceedings against ENRC or its subsidiaries or their employees. Again, a bit of a mouthful, but again, the court disagreed with the judge at first instance, really coming back to whether or not litigation was reasonably in contemplation. Moving on, issue 3 perhaps falls away a little bit in light of what Nikki is going to talk about shortly. And also legal advice privilege. This really was the start in recent times of a discussion about whether or not a dominant purpose test applies for legal advice privilege points. And in the Court of Appeal at this point, there was some suggestion that there was a divergence between, on the one hand, legal advice privilege and on the other, litigation privilege. But that has since been resolved, as we will see shortly. Which brings us on to the case of the Health and Safety Executive against Dukes, which may be familiar to some criminal practitioners, perhaps more than the ENRC. This was a tragic case involving the death of an employee at a waste management company. The issue in the case was really about an interlock which was in place on a large piece of industrial machinery and whether or not it had been bypassed. One of the people involved was this man Dukes, and he, it was said at the trial, was really responsible for the health and safety requirements of the company. And he denied that. He denied it in an interview. He denied it in his defense statement. And that was a major issue in the case. Was he responsible for health and safety at the company or not? The issue then really became one about a signed statement that he'd made about 6 weeks after the incident where this man had tragically lost his life, in which he had said, in direct contradiction to his defense statement and in direct contradiction to what he said in an interview, that he had been responsible for the health and safety at the time of the incident. And at the trial, the judge rejected the suggestion that the statement was privileged. He said that it could be admitted in evidence, and he went through some of the features that we've just looked at. Litigation was in progress or reasonably in contemplation was one of the tests he applied. Also, whether the document was made or created with the dominant purpose of conducting that litigation, and the litigation was adversarial, not investigatory or inquisitorial. And one of the key differences in this case to the ENRC was that the Health and Safety Executive really weren't pursuing an active criminal investigation for quite some significant period of time. There was more of a sort of investigatory role being played. It wasn't an adversarial criminal process going on, in contrast perhaps to the SFO's role in ENRC. And so there's a tension, as you can probably imagine, between ENRC and Dukes. And really what the court did in ENRC was to try and explain that away, and said, well, actually, if you look at how the Health and Safety Executive were behaving, it was quite different from how the Serious Fraud Office were behaving with regard to ENRC. So that is really deep history now in terms of how privilege is approached, which brings us on to WH Holdings and E20 Stadium. Another criminal case, unfortunately, but this was a case arising out of the stadium down at the Olympic Park, and a dispute between the landlord, the stadium, and West Ham Football Club. And the issue was really over the number of seats that West Ham were entitled to use in the arena. That generated a number of email exchanges, and E20, who are the landlords, claimed privilege over a number of their emails exchanged between their board members, stakeholders, and so on. And what the court did in that case, and I'm only going to touch on this very briefly, is that they rejected an attempt to widen any scope of litigation privilege to cover documents which concern the settlement or avoidance of litigation, but which neither sought advice nor information for the purpose of conducting litigation, and which did not reveal the nature of any such advice or information. And so really what the court said there was, well, actually you need to focus in, guys, on what we're talking about when we talk about litigation privilege. It needs to be narrowly defined, and so on. Those points are broadly covered within those bullet points. As Sonal said, these will be distributed at some point in the near future, so I won't trouble you with them again now. And let's move on to the Civil Aviation Authority and Jet 2. Here's obviously the Civil Aviation Authority and Jet 2 on their way into court. Just bear with me 1 second. And really, to come down to brass tacks in this case, this was a case dealing with essentially, presentation issues, the dominant purpose in litigation. So this concerned legal advice privilege, and where we got to at the end of what is quite a long judgment is a decision by the High Court that essentially we are dealing with two branches of the same thing, and that in both litigation privilege and also in legal advice privilege and in litigation privilege, we are dealing with the need for a dominant purpose test. So here we have the judge deciding, paragraph 95, that he was unpersuaded by some of the obiter comments in ENRC. For some bizarre reason, he refers to it as Eurasian in this judgment, but I'm sure we can get past it. And he effectively says, well, look, these aren't different limbs. These are essentially the same thing. And there's no reason for differentiating between the two of them. Consequently, the judge at first instance was correct in deciding that there has to be a dominant purpose within the legal advice that's being given. It can't be less than that. The other important feature of this judgment was that it considers how legal advice privilege plays within larger organisations, and also, crucially, where there are meetings involving perhaps lawyers and non-lawyers, there's giving of commercial advice, and things are slightly more amorphous in terms of the delineation between lawyers and non-lawyers. And what the court did, I think is at paragraph 100 of the judgment, and I'm sure I'll be correct if I'm wrong about that, is that it gave some guidance as to how people should approach it. And I've set it out for you there. The starting point is to identify if an email is being sent to multiple people, or indeed in a meeting. What's the purpose of the email? If it's to obtain legal advice, then it's more likely to be privileged. If it's not, if it's for more general commercial reasons, then it is less likely to be privileged. They also came back to this concept of the continuum of communications, which harps, I think, all the way back to the Bank of England and Three Rivers cases, which need to be taken into account. And the court was at pains to point out, this is bullet point number 3, that if the dominant purpose of the communication is to talk about commercial issues as opposed to seek legal advice or to give legal advice, then it's not privileged, even if there is a subsidiary purpose in doing that. And also that the documents that may be contained within an email chain or within a package of documents need to be considered on an item by item basis. Another key point, and I'm just going to skip over a couple here, is this acid test at bullet point number 7. If the communication had been between only a lawyer and a recipient, would it have been privileged or not? And that is a helpful way the court suggested of considering these matters. A versus A and B in another. Nikki, I think, is going to talk a little bit about this case in due course. And this case really does give us some helpful understanding about how the courts will apply some of these more amorphous concepts, which I've been sort of wading through over the past 15 minutes to physical documents. This was a case, again, under SATCAR. The litigation was between A, who was a retailer, and an auditor, B. And the Financial Reporting Council effectively were asking B to hand over documents where A claimed privilege over them. And so really, there was a huge discussion in that case, and I won't bore you with all the details at this stage, as to how privilege should be dealt with, what was the appropriate course that the court should take, what was the appropriate procedure that the court should take. But ultimately, what the court decided to do was to review a number of categories of documents. I think Nikki is going to go over those for us shortly. I'm just going to touch on one other case or two other cases very briefly before handing over to Nikki. The first is Barafen Properties and Patel. This is a case that came out on the 24th of September, so really pretty new stuff. It doesn't really have a lot of information that's useful to criminal practitioners per se, but it's a helpful reminder of one particular area of privilege which doesn't seem to get very much attention, which is the iniquity exception. And for those of you who couldn't remember what that is, that's where really the documents are being generated and the discussions are being had for the purpose of pursuing a fraudulent purpose. And what the court has said really is where that's the case, legal advice privilege or litigation privilege won't apply. That picture was simply a nice little image I found of the disputed property, but we'll move on very quickly. And then finally, FRC versus Fraser's Group. This is a case, again, involving documents of a similar kind to A against B, which we'll hear about again in a moment. And again, there's another examination by the judge of these documents and of types of documents and the consideration by the court as to whether or not legal advice privilege, litigation privilege attaches to documents. And ultimately, again, the judge came back to the question of whether or not the sole or dominant purpose was for litigation or not. And so that's why I've been at pains to try and emphasize that test over the past 15 minutes or so. I see it's now at 6 o'clock, dead on. I think I might be slightly over. So I'm going to hand over at this point, stop sharing my screen and let someone much more knowledgeable than me talk to you about legal advice privilege and litigation privilege.
Nick, thank you very much. And yes, that was a barrister's 15 minutes. So we'll let that go and we'll hand over to Nikki. Nick.
Well, good evening, everybody. Yes, that was a barrister's 15 minutes. I'm hoping to be a bit quicker because I can see the time and we haven't got that much time left. So let's start with the basics very quickly. The approach of we have a lawyer in the room, therefore everything's privileged is obviously a falsehood. and of course stamping confidential and privileged across the top of your documents, although there's no harm in doing it, doesn't make it privileged either. So what comes from all of these decisions this year really is that when looking at the issue of privilege, it needs to be done with perhaps a slightly more critical eye than had been done previously. Now, going back in time, and you'll know what I mean when I read you the quote I'm about to read, before women like me were allowed to practice, the case that was released last week quotes from a case in 1876, which really sets out what the purpose of privilege is. So I thought I'd read it to you. It's Anderson versus the Bank of British Columbia, 1876. And in explaining the basis of privilege, what was said by the Master of the Rolls was this: the object and meaning of the rule is that by reason of the complexity and difficulty of our law, litigation can only be properly conducted by professional men. It is absolutely necessary that a man, in order to prosecute his rights or to defend himself from an improper claim, should have recourse to the assistance of professional lawyers, and it being so absolutely necessary, it is equally necessary, to use a vulgar phrase, that he should be able to make a clean breast of it. The gentleman whom he consults with a view to the prosecution of his claim or the substantiating his defence against the claim of others. You cannot ask him what the information he obtained was. It may be information simply for the purpose of knowing whether he ought to defend or prosecute the action, but it may be also obtained in the shape of collecting evidence for the purposes of such prosecution or defence. All that, therefore, is privileged. And in fact, although this was written in 1876, the main crux of it actually hasn't changed that much, although there are some other things about which he speaks, which have moved on just ever so slightly. When documents are ordered to be handed over, often the only reason for not doing so is privilege. So I'm firstly going to talk about the case of A and B, the FRC case that Nick was talking about, which was regarding auditors and the audit and was under SATCAR. They reviewed the test set out in JET 2, which reinforced that the requirement to assert legal advice privilege is subject to the dominant purpose test. And they looked at different categories of documents during the course of that case. And what I'm going to do is I'm going to go through those sets of documents, just setting out why it was or wasn't that they managed to keep their privilege or why they were ordered to disclose. The first set of documents were some executive committee minutes. These were described as minutes of the executive corporate governance group. The judge noted that the documents appeared to be a fairly straightforward record about what was being discussed at a number of meetings and didn't on the face of the documents record any legal advice. The judge rejected submissions that the documents were created by the General Counsel in a legal context for the dominant purpose of providing legal advice. Now, that was done basically because when you looked at the metadata for the documents, the last person to have modified them was in fact Company A's General Counsel. But what the judge said, and it's an important thing to think about, is that concluding that the claim to privilege wasn't established, he said that lawyers, and particularly lawyers within a company, often fulfill different roles. So the judge said that they fulfill almost a secretarial function in the context of recording discussions of important meetings, and that in that context, there is nothing to indicate in relation to these executive committee minutes that the GC was doing anything more than that. So this document had privileged and confidential stamped across the front of it, and the judge, considering that, said, well, you know, the fact that somebody stamped that across the front of it means that they thought it was privileged, but that's not the test. We need to ascertain whether in fact they actually are. So looking back at our test of dominant purpose of the document, this document had what would, you know, sometimes be considered the classic ideas that there was a lawyer in the room, it had privilege stamped on it, as we said flippantly slightly at the outset, but that doesn't make it privilege, and the court found that it wasn't. Because in this instance, the role of the lawyer was not one of giving legal advice, and the minutes were therefore just a recording of what had happened. and therefore there was no legal advice being given and privilege can't attach. The second set of documents that were considered were board meeting minutes. These minutes were created by an external law firm, by a solicitor, and the argument centred that these were prepared in order to advise the board as to the topics to be discussed. It was said that privilege arose because it amounts to the preparation of a confidential document in a legal context for the dominant purpose of providing legal advice. Well, the judge in this case, in looking at these documents, decided that there was insufficient evidence to demonstrate the factual position that was being contended for, because the judge was of the view that the likelihood, speaking practically, was that these minutes were probably prepared by the solicitor after the meeting, and that there was no evidence that was placed before the court from the solicitor who produced the minutes, nor any explanation as to why they didn't. So in summary, again, this was more a record of the meeting, which didn't expressly record any communication of any advice, and it didn't reflect any advice that had been given either. So although in this case there was an external solicitor, which sometimes means that you've got a greater indicator of legal advice being given because there's less scope for being part of the business but advising in a different capacity, these documents themselves didn't explicitly demonstrate advice being given, and then there was no evidence that was produced from any other source. For example, the solicitor didn't make a statement or saying why they were taken, what the purpose of them, what had been in contemplation at the time, nothing of that sort. It's hard to know whether, given the nature of these documents, if that evidence had been available, whether the decision might have been different. But as things stood, they were simply a record being produced, and therefore, again, privilege didn't attach. They couldn't retain the privilege that they sought. The next set of documents related to the company's risk register. And again, that was prepared by Company A's general counsel, and they said that that was for the dominant purpose of providing legal advice. In it, of course, dealing with both legal and commercial risk. The judge considered the document and concluded that it didn't declare the substance of any advice again, so as before, within the body of the document. And so in his view, the claim to privilege was only inferential at best, which wasn't sufficient. He relied on an older case of Atos versus Avis, 2007 case, which notes that a document isn't privileged simply because it takes into account legal advice. It's really the dominant purpose test, just said in a different way. So in considering the risk register, it would seem that they came a little bit closer, but sadly for them, not close enough. And so again, although this was prepared by their GC, we again go back to the dominant purpose test, which is now very firmly established within these cases. When looking at the register, it didn't declare any advice. It was inferential, not enough, and therefore it didn't meet the test for privilege to be retained again. And the last set of documents within the case of A and B was a draft of the chairman's script. Now, what they argued was that the particular version of the document before the court had been prepared by a lawyer from an external firm, and the lawyer had made comments on the draft, which in fact only amounted to one tracked change, which had been deleted but was still visible. And so they said that privilege was engaged. The judge concluded that there was nothing to indicate that there was communication of legal advice outside of that one track change. And so what he did was he said that the document was capable of redaction, and the remainder of the document wasn't privileged. And that's something that's been quite common, particularly in relation to emails and attachments. The email may be privileged, but the attachment isn't necessarily. And so the courts have been drawing a distinction between those two things. So again, this document doesn't fulfill the dominant purpose test, and there was no evidence of communication of legal advice. Moving on to the most recent case, from which I quoted at the beginning, was decided, I think, at the end of the summer, but the judgment only came out last week. They were claiming litigation privilege over a small number of documents which contained advice from an accountancy firm about the company's tax structure and VAT obligations. It was largely about restructuring because the old structure was already the subject of challenge by a number of different foreign tax authorities. And I think in some places it had already resulted in litigation. The argument failed on the grounds that although the documents might have been created at a point when litigation was being considered, the documents weren't prepared for the sole or dominant purpose of conducting the litigation that referred to that old structure, so the structure that was being investigated in other jurisdictions. The purpose really was to recommend a new structure and to explain how the VAT was being accounted for, and so therefore there was no privilege. On a side note, this case is quite interesting because it considers the way in which corporates work with their non-legal professional advisors. And in fact, it also does quite a good overview of a historical sort of synopsis of the case law towards the end of the judgment. We can provide that at the end of the webinar as well. So just to finish off quickly, I think I'm being good on time. Things to remember. If you want privilege to attach and you want to retain that privilege, then you need to make sure that you have fulfilled the tests. Particularly important when considering lawyers in-house. Examine critically what function are you performing. Is it that you're documenting what's happening? Is it that you're advising really in a commercial sense as opposed to providing legal advice? Secondly, there needs to be evidence. Try to ensure that legal advice, if it's being given, is evident, either on the face of the documents or that it's easily demonstrable by evidence. The Three Rivers ruling, as Nick's already said, still holds good. It would appear that almost in every single case, there's a comment essentially saying that we'd like something to go to the Supreme Court, please, so that this can be reviewed. But as it stands, everybody's bound by it. So it's important that the client team is identified, and it's important that all of that is defined in instructions, in engagement letters, in protocols, so that it's clear, so that there's actual evidence of what it is that you might want to argue later. It obviously needs to be kept under review right the way throughout, and of course, no sending out the material to lots of people, because that's a very quick way of losing your privilege. So is there evidence that legal advice is being given, and is the document's dominant purpose the communication of that advice? When we're talking about evidence, that either comes from the document itself or from somebody providing evidence, setting out the nature of the legal advice that's being given. Lastly, really, dominant purpose. Don't add written commentary to privileged documents, because that is likely to end up being not privileged. It's essential to be clear as to the purpose of any investigation. If the purpose is for anticipated litigation, then that needs to be set out clearly. So again, in the letter of engagement, letters inviting employees for interview, and that's the topic that Matthew's going to deal with in a moment, because it's a bit of a topic on its own. And even in instructions to forensic accountants, the details should be included, for example, why litigation is contemplated, anticipated parties, issues, but this, of course, all has to be in terms that the client would be content to deploy in support of a claim for privilege later. If advice is being sought, which has more than one purpose, as it often does, there's obviously often a commercial case within the advice that you're giving. It's important to set out what the dominant purpose is and why. And just to conclude, UK regulators and prosecutors seem to be, given the amount of litigation that there's been this year, increasingly willing to challenge privilege claims. So careful consideration of these matters that I've outlined and Matthew's going to deal with will at least inform you as to the likelihood of retaining privilege down the road if it ever comes to it. So that's it. I'll hand over to Matthew. Thank you.
Nikki, thank you. Matthew, over to you.
Thank you. There are many reasons why it's desirable for individuals during the course of cases for this to evolve into witness evidence. The purpose is usually to explore and test potential wrongdoing. However, it can also support or serve to test a case. Although information from witnesses can be valuable, careful consideration should be given to what might happen to the preparation material, eventual work product of interviews, and how to safeguard against potential calls for disclosure of this material, whether it is by the individual or state authority. So what are the issues? As we've heard, with both litigation and advice privilege being strands of the same principle, they each require the client to demonstrate a dominant purpose. In relation to advice privilege, the dominant purpose is to obtain or give legal advice. And for litigation, the dominant purpose is that litigation. The latter remains the most inclusive due to the wider class of people and documents to which it can apply, providing all other requirements are met. Even with the introduction of the dominant purpose test for advice privilege, the main issue, as far as internal investigation interviews are concerned, remains that the interviewee is most likely not going to be part of the client group engaging with the lawyer. Any claim on advice privilege only will therefore fail over the interview records and communications with the interviewee. Privilege may extend to any preparatory material, but that will only be the case, as Nikki has said, if the dominant purpose is the seeking or the giving of advice. I will go on to explain the steps which can be taken to support a claim of privilege, although there are no guarantees. In relation to litigation privilege, the main hurdle likely to be faced since ENRC is demonstrating that the adversarial proceedings were reasonably in the client's contemplation. In ENRC, the Court of Appeal were clear that that where a company investigates an allegation of criminal wrongdoing, regardless of any intention to self-report, which may eventually fail, documents created in an investigation can be for the dominant purpose of adversarial proceedings and thus attract litigation privilege. But the operative words there are can be, and therein lies the risk. What was apparent from ENRC is that what would qualify is incredibly fact-specific and relies on evidencing what was in the client's contemplation. For a client, there is still a high degree of risk involved, which is why it's best to consider certain issues at the outset. I appreciate that time is always of the essence in cases in which we are involved, but before any interviews and investigations are considered, time should be taken to plan and for important decisions to be documented. This is why it is so important to instruct external lawyers so that the investigation can be planned and conducted in a way which best suits the desired outcome and maintenance of privilege. The matter may involve an individual or a corporate, but you should think about and document who the client is and who will provide instructions. This can include a specific committee tasked with dealing with investigations and liaising with the lawyers, or perhaps a client's family office. Care should be taken to ensure that whoever they are the only ones who communicate with the legal team, as this will remove any misunderstanding or potential inadvertent waiver later on, as employee communications are unlikely to be privileged in internal investigations. And once confidentiality is lost, so too is privilege. A bit like my screen then, I don't know what happened there. Before embarking on interviews, thought should be given to whether interviews are in fact necessary. For example, a review by lawyers of internal documents followed by the provision of a reasoned advice note may achieve the same goal whilst maintaining advice privilege. If employees are to be interviewed, then keep matters separate. Interview records should be kept as factual as possible in case they are to be disclosed. The lawyers can then prepare advice notes following interview, assessing risk and advising on the programme of next steps. Equally, standalone notes from employees and or the clients should be avoided and replaced with factual information being included in draft notes setting out the advice sought. Timing has already been mentioned, but an early interview is one thing, but the preparation of a witness statement is another entirely. If it is not possible to argue that litigation is in contemplation, then consider whether it might be better to pause before preparing witness evidence at all, the preparation of which is likely to be privileged as it would cover third parties. This will need to be weighed up with the risk of losing an opportunity, of course, to get a sworn account from someone later. Also be careful in civil proceedings when referring to evidence not served, as this may also amount to a waiver. The pursuit of privilege, for example, in a civil context is likely to be clearer than in the criminal jurisdiction, where a corporate client may be looking to gain the gold star of full cooperation from the SFO. This is where identifying the end game early on is so important. In this situation, a client may have a good claim to privilege, but knows that ultimately they will be considering, at the very least, a limited waiver. If you know from the outset that you are likely to need to provide privileged material, then you can plan accordingly for that event. If self-reporting is a possibility, it may also be appropriate to forego any disciplinary or other internal discussions with your witnesses. Just a note of caution on a limited waiver, especially as we deal with multi-jurisdictional matters more frequently. Consider what other jurisdictions may be relevant to your matter, as the rules in this country may not apply in those. So, for example, in the US, a limited waiver of privilege is not recognised. And in the UK, any waiver will be objectively judged. On that, I won't go into it now, but see the case of AL against the SFO. If, as is often the case, there are threatened parallel civil proceedings, then consider whether you can take witness statements from people not involved directly in the criminal matter. Also consider the likely timetable in the civil proceedings carefully. In relation to the interviews themselves, make clear from the outset that the privilege which may or may not attach to that part is your client's and not the person being interviewed. That will remove any potential misunderstanding later on. And lastly, but I think most importantly, you should document each and every decision which may be called to assert privilege. If you find yourself in a similar position to ENRC, then you want to be able to point clearly to documents which demonstrate contemporaneously the intention of the client when engaging with their advisors. You don't want to be left with the hope of inference over a series of events which may have occurred many years previously. That's all I have to say, which we'll be glad at 6:25.
Matthew, perfectly timed. Of all of our speakers today, you kept your timing the best. Second prize goes to Nikki, and I'm afraid, Nick, you get the last prize. Thank you very much to all of our speakers. There is one question from Colin, and Nikki, I don't know if you've seen it in the chat yet, but it's helpfully directed at you, so I'm going to read it, and I hope I do the question justice. Does A and B merely confirm existing principles? Party B should determine whether the documents in question were privileged because it is the entity by whom the duty to disclose on service of a statutory notice is imposed. If Party B makes the wrong decision in relation to privilege, it would then be liable to Party A if it failed to maintain a privilege it was under a duty to maintain. So Nikki, a question to you first, or anyone else who wants to jump in?
Actually addressed to Nick, and he's already messaged me to say that he's going to deal with it, so I'll...
I'm sorry.
I'll just message you the answer. It's a good question by Colin because effectively it turns one of the paragraphs from the judgment on its head. The answer, I think, to Colin's question is yes. What Mr. Justice Trower, I think, said in the case was, it is for B to determine whether the document is privileged, not because it's under no obligation to disclose it if it makes a determination that it is, but because it is the person by whom the duty to disclose on service of a statutory notice is imposed. If it makes the wrong decision, it will be liable to A, if and insofar as it has failed to maintain a privilege in respect of which it was under a duty to A to maintain. So I think the summary of that question is yes, Colin, it is.
Thank you. I'm looking to see if there are any other questions. None immediately, which, given the time and the fact that everyone only has 2 days left of inter-house mingling before further restrictions are imposed, is probably no bad thing. Can I please end by thanking all of our speakers? I'm sure you'll all agree they've done an excellent presentation, and in trying to condense what is clearly a very complicated area, and in fact forever developing area, as we've seen by the cases that we've seen in this past year alone. So thank you very much to all of you. Thank you to the Female Fraud Forum for supporting us today, and thank you to all of you for attending. We really do appreciate attending seminars in this way. Evenings in particular, I know, are precious, so we're very grateful to that. And keep an eye on our website for the next one, which we hope will be in a very, very short while. So thank you very much. Thank you to our speakers, and stay safe.